All right. So, good evening. We are learning Masechet Makkot, Tractate Makkot, page 3a. All right. Now, we started just touched on it. We touched on it last time, and let me just make sure that I'm just muting you as however you are. If you want to ask something, go ahead. But otherwise, I'll just keep it mute. So, you're unmuted. Wow. All right. We started on it, but it's a very interesting piece of Gemara that teaches us a bunch of things by asking questions in an interesting way. So let's just go ahead and see what it is. So, Amar Rav Yehuda, Amar Rav. We're talking about conspiring witnesses, right? And the conspiring witnesses are those who gave testimony, and when they gave testimony they gave testimony about a certain case, and another set of witnesses came and said that they were with them somewhere else, so they couldn't have seen the crime in New York when they actually were sitting in Florida on the beach. So, the law for conspiring witnesses is that they have to be punished the same way, in the same punishment that they want to inflict on the victim. So, if they came to court and they testified that someone owes $1,000, okay, that we saw that you borrowed $1,000, and therefore you have to pay $1,000, and it turns out that those witnesses were conspiring witnesses, they have to pay the $1,000. So Amar Rav Yehuda Amar Rav. So Et Zomeh Meshalem Lefi Chelko. So witnesses are not coming in Jewish law. They're not coming as individuals. They're coming as a set. Okay, at least two. And so what happens? One witness is a conspiring witness. So he pays according to what he to his portion in the crime. So if it's two witnesses, they split it 50-50. If it's three witnesses, they're dividing it by three. Everybody gives a third. Okay, so so that's what Rabbi Yehuda Amar Rav says. Et zomeh meshalem lefi chelko, that the conspiring witness pays according to his share. That's the statement. Now we have to understand what he means. Okay, so we start by understanding it the simple way. You know, what does it mean? It means that each witness gets the portion. What we just said, that if it's two witnesses, they're dividing it 50-50, etc. So it says, "Mai meshalem lefi chelko." What does it mean? Ilei madai meshalem palga vai meshalem palga tanina meshalshim b'mano meshalshim b'makot. It says, if this is what Rabbi Yehuda Amar Rav wants to teach us, this is a known. It's a known halacha. It's a known detail. We know it already. How do we know it? Because there is another Mishnah that says clearly that you have to split the money amongst the conspiring witnesses, the punishment. So if it's $1,000, you split it depending on how many witnesses. However, if the conspiring witnesses are obligated to receive lashes, they're not splitting the lashes. Lashes, you have everyone, lashes is 39 lashes, right? So each one gets their own piece. They cannot say, okay, you get 15 or 20 and I'll get 15. It doesn't work that way. So we know it already. So what is here, Rabbi Yehuda Amar Rav saying that Et Zomem is paying his share. We know this. This is not new. So what are you teaching us? Okay. So now the Gemara is trying like three or four times to answer, and each answer teaches us another detail in the laws of witnesses, which is phenomenal, which is really interesting. So the first attempt, and we rejecting each one of them because they don't go according the explanation of what it means doesn't work according to the law. So we're trying to explain the statement that Rabbi Yehuda Marav says that one conspired witness is paying according to his share. So here goes. First attempt. Ela kegon de itzum chad minayo de meshalem palga didei. So the first attempt is, as we're saying, so let's explain it. What does it mean? That if one of the witnesses is conspired, it became conspired witnesses. What does it mean? Two witnesses came to the court and said, we saw this transaction that Reuven lent money to Shimon, okay, $1,000, and therefore Shimon has to pay Reuven. And then two witnesses are coming and say, hey, one of those witnesses was with us in Florida. Not both, only one. So one of them became conspired witness. So what about, so that conspired witness, what does he get? We're attempting to say that he is going to pay his part of the crime. The other witness was not proved to be conspired witness, so he doesn't have to pay. But this one is, so he will pay 50% of the money that he was trying to cause, the damages he was trying to cause. That's what we're trying to explain that Rav Yehuda Marav said. The Gemara is saying that doesn't work. You can't explain it that way. And this is where we learn one detail about the laws of testimony. ומי משלם? והתניא אין עד זומם משלם ממון עד שיזומו שניהם. It says, in Jewish law, the witnesses are coming as a set. And the whole law of conspiring witnesses is that those two witnesses are becoming conspiring witnesses. That otherwise, if we break the package, the set, it's not conspiring witnesses. Meaning, they need to be two in order to be rendered conspiring witnesses, and therefore they need to be punished both at the same time. If they don't, if only one of them is being conspired witness, the testimony is false. So we're not lynching the guy that was testified against. He doesn't have to pay, but the conspiring witness is not paying his half share. He's just getting punished by the rabbi somehow, but not according to the law of conspiring witnesses. So therefore, we cannot explain that statement of that one conspiring witness is paying according to his share. We cannot explain that only one of them is a conspiring witness. Okay, so now we have a second attempt. The second attempt, it says, what are we talking about here? Amarava, we're talking that one of the witnesses is coming forth and saying, I lied. I wasn't in that event, I was in Florida. I couldn't see this. So two guys came, they testified that they saw the event, then one of them later on says, I lied. I was in Florida, I couldn't have seen it. And that's what he means, that guy will pay 50% of the damage. So the Gemara is saying also that this also does not work. Why doesn't that work? Because we have another law, and this is what teaches us another law in testimony. It says, "Kol keminei kevan shigit shuveno chozer." There is a law that says that once the witnesses came to court and gave their testimony, and as we learned probably later, or we learned in Sanhedrin, but the witnesses, when they come to court and they testify, they're being asked a lot of questions by the court, by the judges, and they're asking 7 different questions, standard questions, and then additional unlimited number of other questions. Do you remember the clothing that he wore? Was it shady? Was it rainy that day, etc.? They're being asked a lot of questions. by the time the court is accepting their testimony, this is sealed and it cannot be turned. In other words, if later on that one of the witness, or even both of them, come back and say, we lied, it's not so. You don't accept their second testimony because it's very likely that they were put under pressure. If they were checked properly, so, this is it. You gave your testimony, it doesn't, you're not allowed to take it away. So therefore, we cannot say that what Rabbi Yehuda Amarav, when he's talking about one conspiring witness who has to pay his share, we cannot say that we're talking about a witness that came back and says, I lied. Because we don't listen to him when he says that. That's not a valid procedure in court. It's not a valid procedure in court. Okay, so a third attempt to explain what Rav Yehuda Amarav is saying, Ela beomer e'adnu v'uzamnu bebeit din ploni. He says, we have a story like that. Two witnesses are coming to a court in New York, and they say, we saw that Reuven lent to Shimon $1,000, and therefore Shimon owes $1,000. Then, later on, they go to another court in another city. They go to a court in Boston, and they say to the court in Boston, we told a lie in New York. We actually were not in New York when the loan occurred, or when we said that the loan occurred. We actually were in Florida. So they're coming to the court in Boston and tell them that we are, that we actually were not there. And they said that the court in New York know about it already, that two witnesses came to the court in New York and testified that the two witnesses were conspiring witnesses. This story they're saying in Boston. Okay? So, but only one of the witnesses is saying that in Boston, not two of them. So we are trying to say that witness that was confirming that gave a testimony in Boston and said that he was really conspired witness in New York, that witness, we're trying to say, is obligated to pay 50%. So he says we cannot explain that either. Why? Because there is a discussion somewhere else in the Gemara that just so we understand, Rabbi Yehuda Amarav, those are Amoraim. Those are the scholars, the rabbis that wrote the Gemara. Rabbi Akiva is from the scholars of the Mishnah. Earlier, has much more authority. So the opinion of Rabbi Akiva is, כמה דלא כרבי עקיבא, דאי כרבי עקיבא, אמר אינו משלם על פי עצמו. Rabbi Akiva and the rabbis have a disagreement, okay? And the disagreement, I think we learned last time, and that is, if someone is coming and giving a testimony that incriminate themselves, and they say that I did something wrong, and therefore I'm obligated to pay a fine. So a person cannot incriminate themselves to pay a fine. If somebody comes and say I stole, okay, so they have to refund what they stole. But when someone steals, there is also a fine. They have to pay, if they stole $100, they have to pay the $100 back, but they also have to pay another $100 fine, double. So there is a disagreement whether if someone is incriminating themselves, if somebody is confessing to a crime, do we obligate them to pay the fine? So the rabbis are saying yes. He said that he is a thief, so he is a thief, and you treat him like a thief, and he pays the $100 to give back the what he stole, and another 100 for the fine. Rabbi Akiva says no, that a person cannot incriminate themselves, and they just pay the $100 when they don't pay the fine. And the halacha is like Rabbi Akiva. The halacha is like Rabbi Akiva. And that's how, by the way, the laws that people cannot incriminate themselves, this is how they made their way into the common law from here. So a person cannot incriminate themselves and pay the fine. All right. So if a person cannot incriminate themselves and pay the fine, so we learned last time that the whole halacha of conspiring witnesses is a fine. Because it's a weird halacha. It's not, if someone is trying to inflict damage, why should the damage that they try to inflict will be turned on them? They should get time, they should get lashes, they should... It's a weird halacha that doesn't exist anywhere else in Jewish law. So it's therefore it's considered a fine. So if it's a fine, a person cannot have to pay fine based on their own confession. So if they went to Boston and said that they were conspiring witnesses in New York, they cannot be obligated to pay fine, and therefore we cannot explain that what Rav Yehuda Amarav that said that a conspiring witness pays half according to his portion, his share, that it's talking about this kind of a situation that they went to Boston and said that they are conspiring witnesses over there. So therefore, the Gemara is finalizing and coming up with the final solution, with the final answer, and the final answer is as follows: Ela beomer e'adnu v'uzmanu bebeit din ploni v'chuyavnu mamon. Okay, what they're saying is, again, the story goes as follows: two witnesses come to a court in New York and say that Reuven lent to Shimon $1,000. And then two other witnesses are coming and saying those two are liars. One of them is a liar, and he was with us in... he said that both of them are liars, and he was with us in Florida. Now, what happens is that those conspiring witnesses, one of them, arrive in a court... Now, the court in New York is therefore taking those two conspiring witnesses and rendering an indictment that they have to pay the $1,000. Those two witnesses were conspiring witnesses, they have to pay the $1,000. And that is a sealed indictment. It's finished. And it's now they just have to pay. So now one of those witnesses took off, or both of them, they took off, and they arrive in Boston. And one of them goes to the court in Boston. He didn't pay the $1,000 in New York. He just ran away, and he feels bad about it. So he comes to the rabbis in Boston and say, "This is what happened," and he tells them the story. So now we are not talking anymore about the court in Boston rendering them as conspiring witnesses. That all happened in New York already. And it finished, the whole case finished in New York, and now those people are just two dudes that have an obligation to pay $1,000. The conspiring part of it is out already. It's not important anymore, because that was a case that finished in New York. When they come to Boston, they are just saying, well, we have an obligation to pay $1,000. But only one of them is saying that. You say that you have an obligation to pay $1,000 because a court rendered that verdict. Now it's not a fine anymore. Now it's just, it's just an obligation that you have. It's a debt that you have to the court, so you have to pay it. So in that kind of a case, that one guy came to Boston and told them the story about how they were caught lying in New York, and they have to pay $1,000. So the court in Boston is taking $500 from that guy and close his case. That is what what we arriving at what Rabbi Yehuda Amarav is saying. Now, why are we saying it? Because we said before that we know already that we split the punishment according to the number of witnesses, right? We have a whole Mishnah that says it. So what are we learning now that we didn't know? So the Gemara is saying what we learn now is as follows. Sal kadad achamina, I was thinking that kivan de lechavre lo matzi mechayev le iyunami lo mechayev kamash malan, because that particular witness, that one witness who came to Boston and said, I lied in New York and they gave me a punishment of $1,000, gave me and my friend a punishment of $1,000. He cannot, because he is now one witness, right? In Boston he's one witness. He only came. He cannot, the court cannot take his word and go take the $500 from the other witness, from his friend, right? Because we have only one witness that's testifying in Boston that there is a debt here to the court. So because we would think that because he cannot, is unable to render his fellow witness liable, so because, based on his admission, maybe he should not be liable either. So Rabbi Yehuda Amarav is saying, no, he is liable, and that's basically what the chidush, the new point here is. Okay, are we good? Ready to go? Next. Now we have something really, really interesting. It's one Mishnah with two lines of Gemara, literally 2 lines of Gemara. It's talking about conspiring witnesses in some way, but by learning it, we will learn major pieces of the Tractate of Ktubot, just as by way of introduction. It's not going to take long, maybe a little bit, but it's very interesting how we talk about conspiring witnesses and people can think, what's the relationship? We're going to talk all about Ktubot. All right, so let me first give you a little bit of let's read the Mishnah first, okay? So in the previous Mishnah we were talking about people who cannot receive the punishment of a conspiring witness for various reasons, and instead of the punishment is just getting lashes. Now we're talking about a testimony that that the conspiring witnesses has to pay money, but the loss, we're saying that the conspiring witnesses has to pay exactly the loss that they try to inflict, right? But there are some exceptions. They try to inflict X amount of dollars, but they have to pay Y amount of dollars, less. And we'll see exactly what we're talking about. Okay? מעידים אנו את איש פלוני שגירש את אשתו שלא נתן לה כתובה. 2 witnesses, very nice souls, are coming to court and saying, we know that Mr. Reuven divorced his wife. And we also know that as he was divorcing his wife, he didn't pay her ketubah. And they turn out to be conspiring witnesses. Okay? Now let's review a little bit the Ilchot of Ketubah. You all here were married, right? Married or were married? Good. So you know what the Ketubah is, but let's explain, because we probably all signing things. It's definitely not in English, and it's not even in Hebrew. It's in Aramaic, and I'm not sure that we all know what it is. So let's just explain what Ketubah is. The Jewish law is that when a man is married a woman, everything that she is producing during the marriage is belonging to the husband, and on account of that, he is supporting her. So if she goes to work and she earns money, the money goes to is under his jurisdiction according to Jewish law, and on account of that, he needs to take care of her. Now, and that agreement is written right on the outset in the Ketubah. And the Ketubah is a contract that's being signed right before the chuppah and being read under the chuppah, and so everybody knows. And over there it's written a couple of clauses. Clause number 1 is that the husband is obligating to pay the woman if she is divorced, if he's divorcing her, or he died before her. So then the heirs, which are the kids, has to pay the wife, the widow or the divorcee. They have to pay her 200 zuz, 200 shekel. Okay, if it's first marriage. If it's a second marriage, 100. So that's one part of the Ketubah, one clause. Another clause in the Ketubah is that the husband, because he loves his wife so much and he wants her to marry him, he adds extra. It's called Tosefet Ketubah. Okay? Nowadays, there is Tosefet Ketubah, an extra, an added value in the Ketubah, which is standard, and it's typically 100 zuz. So a person is obligating to pay basic Ketubah, which is 200, plus 100 extra Ketubah. This is also, people usually don't do it. Some in rare cases they do, they are allowed to do. They can promise the world. So they can say, as extra Ketubah, I'm also going to give her $10 million, you know, if we divorce or if the husband dies before the woman. So that's the second clause. So it's Ketubah, basic, 200, plus Tosefet Ketubah, the extra 100. Then there is a third clause, which is optional, which is not in every Ketubah, and that includes the dowry. The dowry is the property that the woman is bringing to the marriage from her father, you know, a camel, a car, you know, half an apartment, whatever it is that she's bringing along. And it's called Nichsei Tzon Barzel. What does it mean? This is there is an assessment that's being done at the time of the marriage, and we assess how much this property that she's bringing in as part of the dowry to the marriage is worth, and then the husband, when he divorces her or dies before her, she needs to get that property back. And she needs to get the property back at least how much it was worth at the time of the marriage. So if it's worth more, let's say she came in and she brought a building in Fifth Avenue, Manhattan, right? So when they got married, it was worth $1 million. Now it's worth $500 million. So the husband needs to give her $1 million, and he can take the $499, you know, and it's his. But if she brought in an apartment in downtown Portland, okay, so it was worth $100,000 when they got married, and now after the riots is worth 10 cents, the husband still has to pay her the $100,000 because it's called Nichsei Barzel. It has a strength to it. They retain the value that's written in the Ketubah, retains its value. So that's clause number 3 in the Ketubah. Now there is something that we need to know because it matters in the Gemara that is not written in the Ketubah, and that is another type of property that a woman can bring to the marriage. Okay, and that is property that the woman is earning while she is married, and the husband cannot really take it away from her. It doesn't belong to the husband. Meaning, it's not money that she earned because she worked. It's money that came to her because her parents gave her a gift, or God forbid the parents died and she got the inheritance. So the inheritance that she got from her parents does not belong to her husband. What happens with this property? This property, the husband is allowed to take the fruits of it. So in those days, what happens? A woman got married, and then her parents died, and her parents had an orchard. Okay, so now the orchard belonged to her. So the husband is allowed to eat all of the fruits of the orchard. Okay, and if the divorce or the husband died, the orchard is going back to the wife, and in whatever condition it is right now. Okay, the husband is not obligated to make sure that it retained the value, the orchard retained the value from the time that the father died. Okay, so those are the 4 types of properties that the arrangement between a husband and a wife. 3 of them are written in the Ketubah, and 1 of them is not. Okay. Now, what happens here in our situation? In our situation is a couple of hoodlums coming to court and saying that this person divorced his wife, and therefore he needs to pay her. So let's take for an example. He needs to pay her now $1,000. Why? Because $200 is what's written in the Ketubah, plus $100 is the extra Ketubah that's written in the Ketubah, it's the clause number 2, and $700 is the dowry. Okay, so now the husband needs to pay her $1,000. Now the hoodlums, we call them, because they were conspiring witnesses, and they were not in town when they say that they were, and therefore we don't have here an obligation to pay. So the question now is, they almost made the husband pay $1,000 to this wife. What should they pay now that we discovered that they're conspiring witnesses? So we would say, without thinking, yeah, $1,000, right? It's not so. Why? It should not really be $1,000, because the obligation of the husband to pay her is still there. It's not eventually, either he's going to die, or he's going to divorce, or she's going to die. But there is 2 out of 3, right? Let's look at it as divorce, death of a husband, and death of a wife. Let's look at it as like three equal possibilities. Okay, so 2 out of 3 cases, divorce and death of the husband, that he will have to pay this ketubah anyway. So the witnesses did not really, they shouldn't be paying that money. They should only pay a certain amount, and we'll see what that money is. Okay. So what do we say? How much do they have to pay? The Mishnah is saying, עומדים כמה אדם רוצה ליתן בכתובתה של זו, שאם ניתן לנו את גרשה, והיא מתה ירשן הבעלה. So we have to assess the situation. What does it mean we have to assess the situation? We have to assess it as follows. We have to estimate how much is this ketubah worth now. Okay? For example, a husband got married, and he obligated with this $1,000 that we used as an example, and then she's strapped for cash. She is strapped for cash. She is holding the ketubah, and she is strapped for cash. So she can go to a pawn shop and say, "Here's my ketubah. I want to sell it to you. So you give me now $300, $400. Give me $400 now. It says that I'm obligated to get 1,000, but you hold it. It's yours. If my husband is going to divorce me or die before me, you can collect $1,000. You give me now $400." That's what she does with the ketubah. So that is the amount of money that we are now turning and saying those conspiring witnesses, this is what the ketubah is worth right now, and therefore you try to inflict right now a damage to that guy, so you pay the $400. That's what the Mishnah is saying. Okay, now let's go to the Gemara and see an interesting twist to it. And you have to have a little bit of a banker's mind. כיצד שומעים את הבעל? אמר רב חיסדא בבעל. So כיצד שומעים. So the question is, what exactly are you estimating? So for that we need another introduction. The introduction goes as follows. Okay. After you sign the ketubah is a contract, and the actual contract is sitting with in the wife's drawer, right? It belongs to her, and it has value. It has value to both people. What does it mean? The wife obviously has a value that if the husband will die or will divorce her, she can go and collect, right? So that's the value that she has. The husband has a value that if she dies before him, he can just tear the ketubah and he doesn't need to pay anybody anything. That's the value that he has in this contract. Okay? Now, the husband has two extra benefits in the ketubah that the wife doesn't have. Benefit number one is that when you sign the ketubah, if you ever read the translation, it says that you obligating all of your property to pay the ketubah first. That's the first in line. That's the first mortgage. First mortgage is a ketubah. So anything that the person owns, whatever money you have in your bank account and your property and your net worth, the first money belongs to the ketubah. Now, as long as the person is married, they still have this property, belongs to them, but they can use it for investment. So let's say you put in your mind, that you have to pay $1,000 in the ketubah if you divorce. So you put $1,000 in the bank. You can go to Robinhood and buy a game shop, and multiply the money and make a bundle while. So you're allowed to do it. You're allowed to play with the money and get the fruit of it. So that's a benefit that the husband has with the money of the ketubah that the wife doesn't have. Another benefit that that the husband have, is that if the wife dies first, he doesn't need to collect anything. The money is with him. The ketubah is rendered useless because the wife died, so he doesn't need to go collect. She, however, if the husband dies or divorces her, she now needs to go to court and collect it, because she just have a ketubah that says she doesn't have a contract. She doesn't have the actual money. So that's a benefit that the husband have. Okay, so with that in mind, that both of them, the husband and the wife, have some benefit in the ketubah, but the husband have extra benefit. Now let's think about the following. What happens if the wife goes to a pawn shop and say, I'm strapped for cash, I want to sell you this ketubah? Okay? So the pawn shop said, I'll give you $400 for this, give me the $1,000 ketubah, and if your husband dies or divorces you, I'll get the $1,000. No problem. It's worth $400. The value that the husband have in the ketubah is more because he has those two extra benefits. So if he is selling that, he would get $500 because he has extra benefit. So his hold on that money is worth more than the wife's hold on that money. So therefore, the question is, when you assess how much the conspiring witnesses has to pay below the $1,000, they don't pay the $1,000 because some of this $1,000 is still an obligation. After the conspiring witnesses come and go, there is still an obligation there for the husband to pay if and when he divorces his wife, right? So the question is, do we assess it based on the value that the wife has in the ketubah or the husband? Is it worth now $400 or $500? That is the question that the Gemara is having. So Rav Chisda is saying that you go according to the husband's value, meaning you have to pay more. And Rav Natan Bar Oshia says you have to go and assess it based on the wife's, on what the wife has in the Ketubah, which is less. I'll pause now if you have any questions because we talked a lot. You all good? Good. Okay. Okay, now a little bit of a twist here, and you see the two things in the two statement here. It says Rab Natan Bar Oshia Omer. Rab Natan Bar Oshia says that you do it based on the wife's the wife's right, based on her obligation. And then we say Amar Rav Papa. We don't say Rav Papa Amar, we say Amar Rav Papa. What's the difference between Rav Papa Amar and Amar Rav Papa? If we are saying that Rav Papa has a third opinion here, because the first opinion was Rav Chisda, okay? Rav Chisda, Amar Rav Chisda Bebal. Rav Natan Bar Oshia says Beisha. If Rav Papa disagrees with Rav Natan Bar Oshia and with the Rav Chisda, he should say Rav Papa Omer something else. We don't say that. We said Amar Rav Papa. That tells us that Rav Papa is just adding a twist here, an extra explanation. He actually feels exactly like Rav Natan Bar Oshia. He doesn't disagree with him. He just adds a little bit of a twist here. And what is the twist? The twist is based on what we discussed before. What did we say before? That there are 4 types of properties that exist between a husband and a wife, that belongs to the wife, right? Number 1 is the Ketubah. Number 2 is the extra Ketubah, $100, right? 100 Jews, shekels. And number 3 is the dowry that she brings in. Those are the 3 types of properties that are written in the Ketubah, right? And we know exactly how much they are. And based on that, we gave an example of a Ketubah that's worth $1,000, right? The Ketubah, the basic Ketubah is 200, the extra Ketubah is 100, and then 700 is the dowry, and that's the total value of the Ketubah is $1,000. Now, but we also mentioned that there is another 4th type of property that exists, and that is the property that she brings, like with her inheritance. Nichse milug it's called, right? That the husband can reap the benefit of the orchard, right? But he's not obligated to pay the value of the orchard if they divorce. So Rav Papa is saying that when you assess the value of the obligation between the husband and wife, you only look at the 3 types of properties that are written in the Ketubah. You exclude from it totally the 4th type of property, which is what she would have gotten with her inheritance. Why? Because that type of property is not known. If you recall, in your wedding, you were standing under the chuppah, you had hundreds of people around, or whatever, tens, whatever number you invited, and you read publicly the Ketubah. So everybody heard. So everybody knows about your obligation for those basic 3, the basic Ketubah, extra Ketubah, and the dowry. Everybody knows about that. But nobody really knows how much a person got how much a wife got in her from an inheritance or some money that came to her later on during the marriage. So therefore, the conspiring witnesses who were trying to inflict pain on this couple, on this husband, didn't even take that into account, so they cannot be held accountable for it. Amar Rav Papa, B'isha B'Ktubata, we're only assessing the value of what they need to pay based on the principle of the Ketubah, not on the extra money that she might have gotten during her marriage. And I think this is probably good enough for today. All right?
Thank you, Dor.
Any questions? Good night. Any questions? Anything? Good?
Very good, Dor. Very
Okay.
good, thank you.